Georgie said, my presentation is going to narrow a little bit the focus, and I'm going to talk about the international human rights standards on combating violence against women applicable to the European context. So this is what I'm going to do, and not necessarily looking at the context of war and violence against women as it happened during the war context, but in peace and everyday kind of business kind of situation. So and this is sort of, there's an early, so there were some obviously early events taking, or instruments taking place at the United Nations system. So 4 of them I've listed, some of them I've listed here, but as you can see actually most of them at the time, initially the framing was rather limited in terms of looking at, as you see, like first of all it wasn't even framed as violence against women, but mostly in terms of violence within the family. Then there was a resolution, a General Assembly resolution on domestic violence. You often find as well the criminal law response to punishing violence against women. So that is sort of the early stages. But then I think there was a turning point in sort of the early 90s, and especially I think with the Beijing conference, where women's associations, and I think here I cannot highlight the importance in all of this domain, the role that women's NGOs, women's organizations played. It's been crucial, not just in developing these tools at the international law level, but also later on in framing and conceptualizing violence against women as a form of discrimination. So not just the NGOs, but also female legal theorists that have been very, very important in framing these issues, and some of the things that we're seeing today are the fruit of what has happened in the past. So I cannot highlight the importance more. Then at the UN system, so beyond these instruments, obviously the CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, has been extremely important. The interesting thing is that violence against women in that instrument was not mentioned. So at that time, so violence against women was not even in what has been defined the Women's Bill of Rights. But that has been inserted via the activity of the CEDAW committee. So you see a number of recommendations, general recommendation, a procedural recommendation that asked states to inform what they are doing to combat violence against women. So that was just a procedural to put into the state reports that the states have to provide CEDAW regularly, to put information in there. But the more important, that's why I highlighted it in red, general recommendation number 19, probably that recommendation here has been the one where at the international law level you have a first comprehensive attempt in trying to frame issues of violence against women through the lens and framing them as an international human rights violation as such, and in a broad sweeping way. So it's a very important instrument here in 1992. But the committee has been very active as well in dealing with individual decisions. So there's an optional protocol to the CEDAW convention, and under that convention individual complaints can be lodged to the committee, and a number of them, actually a big majority of them, have been dealing with issues on violence against women. I'm just listing some of them here in terms of topics that the committee has been dealing with. The issue of rape and the conjunction with stereotypes. So the committee has been dealing with these in 2 cases concerning the Philippines, and sort of judicial stereotypes about rape victims, where the committee said this is a violation of the CEDAW Convention. There's a second point, forced sterilizations here, AS versus Hungary, the practice, and we'll get back to those with the European Court of Human Rights case law on these issues, the forced sterilizations of Romani women. There was one decision here in 2006 on the practice in Hungary, condemned by the CEDAW committee. There's a number of cases on domestic violence. I think those are really, really crucial, and basically the non-activation of the institutions of dealing with domestic violence, either at the police level or at the prosecutor level. So there's a number of ways in which these domestic violence cases have picked up or have taken up. The interesting thing is here as well that a number of those involve women of belonging to racial minorities. So the issue of intersectionality creeps up in most of the cases that are actually listed here. One last question, case deals with maternal death. This was a Brazilian case here. But the important thing is it's not just the CEDAW committee that has been dealing with issues of violence against women and condemning them as human rights violations. Under the ICCPR, the Human Rights Committee also deals with individual decisions, and there have been 2 cases here. LNP versus Argentina. This was a case about discrimination against an indigenous girl, a victim of rape. The second case against Uzbekistan was about a human rights activist who found herself gang raped as well and forcibly sterilized by the Uzbeki institutions. So that has been seen as well and framed as a human rights violation. So again, we see the question of framing these issues as violence against women has been important, and the case law is actually huge. And I do realize that in terms here, we're not really talking about prevention, but actually what happens after that. But even that is important, because once you've elaborated applicable standards, it can help in the litigation, at the litigation stage, once you get to either the human rights committees, but I posit as well, hopefully in national cases as well. In terms of moving things forward in the applicable standards to Europe, as you see here, there's a whole list of cases. The European Court of Human Rights has been incredibly active in this domain, especially in the last, I would say, 10 years, mainly starting from the Opus versus Turkey decision that I've highlighted in red. But there's earlier ones, early cases dealing with rape and assault, X and Y versus Netherlands, an early case, MC versus Bulgaria, YV versus Slovenia, the forced sterilization cases on Romani women as well. So dealing with questions of reproductive freedom. So you see 3 cases here, mostly dealing with Slovakia and what happened there. And the interesting thing is on domestic violence, it's particularly on domestic violence that we see real progress in terms of the court framing, also conceptually framing how to deal with those. So you see some of the early cases that deal with Article 8 violations. Now Article 8 is the provision that talks about right to family life. So initially the cases of domestic violence were framed as, well, right to family life and that the violence that women suffer within their family from their partners, from their former partners, is a sort of, violation of her right to a harmonic family life. So it didn't even get to the point of framing this as inhuman and degrading treatment. So conceptually framing that as an Article 8 issue and not as an Article 3, which is the prohibition of inhuman and degrading treatment, that has been the jump that the court has done from the earlier cases. Every now and then it still crops up, this discussion about Article 8. But rather than framing it as Article 8, I posit that the better cases are the ones where the court starts framing these issues legally as inhuman and degrading treatment, not just for simple, conceptual and theoretical reasons, but as well in terms of damages that the victims can claim. There's a clear difference between getting money out of an Article 8 claim and rather one for Article 3. Needless to be said, most of the women that are claiming that are bringing these claims here are not doing it for monetary reasons. This is something that I really want to stress, because often it comes up sort of as a discussion point, oh, these women want to make money out of the violence suffered. No, this is not the case here. It's about conceptual framing and understanding domestic violence in particular here. So the leading case here is still Opus versus Turkey, very important decision, which dealt also with Article 2 violations, because it was the mother of the mother or the daughter was killed by the violent husband of the daughter. I think that was the case. So it was a right to life and prohibition of inhuman and degrading treatment case. And the court found, interesting enough, that this was not just Article 2 and Article 3 violation, but also that the institutions hadn't done anything to prevent the violence from happening, because the police came and said, oh, it's all fine, and then just left and went away. So in the end, after numerous repetitions of violence, in the end, one of the family members died, and so that the court found was a violation of Article 14 as well, because of the sort of discriminatory understanding by the Turkish authorities of this violence. It's family stuff, we're not going to put our hand in there. So there was that aspect here, and so the court did find an Article 14 violation here as well. If you want to read, this is why I highlight the other case, Valiuliene versus Lithuania, 2013. If you want to read a gender-sensitive judgment on the issue of domestic violence, read that case. The main case itself was already interesting, but then there's a very interesting concurring opinion by the Portuguese judge Pinto de Albuquerque. So have a look at this case here for that concurring opinion. It's an incredibly interesting understanding of what a gender-sensitive interpretation of the convention means in the context of violence against women, because here we weren't talking about heavy instances of violence and death. This was a relatively, let's put it this way, mild case of domestic violence that Mrs. Valjuliene suffered, and still the court went all the way to finding an Article 3 and an Article 14 violation. So very interesting case. So that has been followed by a number of judgments. There's two interesting judgments against Italy, and here I just want to stop briefly on this 2014 decision, Rumor. The court didn't find any violation. It said the legislative framework that had been put in place was sufficient to protect women in Italy from domestic violence, and basically didn't find any violation. And 3 years later only, the court in Talpis found that there was a violation. So the same framework, but that there was different reactions probably on the sides of the police, but also the prosecutors in this domain here. So you see a lot of case law that has developed here that really has established the European Court of and real human rights standards in this domain in dealing with violence against women. But obviously, in the Council of Europe system, there's no way talking around Istanbul Convention. I'm not going to go into the details here, but the focus, as opposed to other international conventions dealing with violence against women, and I'm thinking particularly about the Belém do Pará Convention, the American Convention in the Organization of American States. That convention was focusing heavily on criminal law sanctions. So basically it was all about, well, have you established criminal law sanctions to punish violence against women? And that's it to some extent. Here, the convention is much broader, and it talks a lot about the question of prevention, a lot. So it's taking a holistic approach in combating violence against women. So you have the different titles here. So you see a lot of it before you actually get to the definitions and what kind of things need to be applied here. We talk about policies, data collection, prevention, protection, and support. So it's a very, very broad framing here. And the interesting thing here is that then only in Chapter 5 you get to the substantive law, what kind of things should be punishable under the Istanbul Convention, which kind of procedures. There's the issue, the question of migration and asylum, international cooperation. There's a monitoring mechanism, there's a committee that has been founded, the Grevio committee that has started operating. I think they've just been in Montenegro now and visiting recently, was it 2 weeks ago? So they're starting to be operative. They don't take individual cases. That's one of the things that is maybe the downside of this. But again, the interesting thing is talking about Hungary. So it was signed on 14 March 2014, and this spring actually, we're thinking we're almost there, ratification is happening, and then all of a sudden it disappeared. I have no idea what happened specifically in that political process here, but the ratification of the Istanbul Convention, I think, would be politically a very important sign to send for Hungary to sign this convention for a number of reasons, because the other one that actually started signing it, and that was a big surprise for me, is that the EU signed this convention. So when I was talking to the European Commission, a representative at the European Parliament, they said there's no way. 2 years ago they said there's no way that we're going to sign this. The fact that we ratified the UN Convention on the Rights of People with Disabilities was an error. We're not going to sign, we're not going to ratify Istanbul Convention. But instead, all of a sudden, I realized or saw that the 13th of June 2017, the European Union actually signed the convention. What that means in terms of then applying to countries that haven't ratified the convention yet is still to be seen. But I think it is an important sign, and maybe that links this presentation a little bit to what Christina was saying as well, on the question of the EU activating itself on also issues of prevention, and here specifically in the prevention of, on combating violence against women. One last slide that I wanted to show, obviously there has been international standards also on the question of trafficking of women as one form of violence. So there has been earlier conventions, numerous UN conventions actually dating back, obviously 1910, they weren't United Nations, but League of Nations. But there's been conventions dating all the way back to 1910. But there's an important, the Council of Europe Convention on Action Against Trafficking in Human Beings, as a policy or as an instrument, but also there's been a very important decision and judgment by the European Court of Human Rights, Ráday versus Cyprus and Russia, that was dealing with the trafficking of Russian women from Russia to Cyprus, and the father of one of these victims who actually died in Cyprus in unknown or rather unclear circumstances, sued both Cyprus and Russia for failing to protect his daughter and for failing to protect his daughter's life. So I just wanted to give you a sense of what the picture is here. I mean, I know it's a very sort of quick overview of what is happening, but the framework in terms of international human rights standards that is taking place at the European level might be actually something that can help in further developing these standards elsewhere. So I think it's very interesting to see what is going on, and again, I cannot highlight this more enough, the importance of women's rights movement and of feminist legal theorists in putting this framework, in helping to develop this framework. I think it's crucial because without their intervention, none of this would be here. So thank you very much, and I'm looking forward to the discussion.